What are my options if I can't afford my mortgage or if I'm faced with foreclosure in California? This video is not meant to be taken as legal advice and should not be relied upon as such. There's no substitute for an actual consultation with an attorney. The intention of this video is to offer consumers some basic information to allow them to better understand their situation and, if necessary, to have a more meaningful consultation with legal counsel. First, it's important to determine if your lender has recourse against you. Please see our video entitled, Will I Owe Money After Foreclosure in California? As I see it, distressed homeowners have 5 basic options. 1. Do nothing and try and stay in the home for as long as physically possible. I've heard stories of people who have been able to stay in their homes for over 2 years without making a single mortgage payment. 2. Strategize, preferably early on and preferably with qualified legal counsel. I suggest starting by sending 5 letters. A qualified written request under RESPA, the Real Estate Settlement Procedures Act, a qualified written request under California Civil Code, Section 2943, a validation letter under the Fair Debt Collection Practices Act. The lender will likely not respond to these first 3 letters appropriately or within the statutory period of time allotted, and voila, you've created violations of federal law that you can use against your lender. The 4th letter would be a reinvestigation letter to each of the 3 major credit reporting agencies, TransUnion, Equifax, and Experian. You need to challenge any negative reporting by the lenders. 5th, if appropriate, send the servicer a letter of rescission under the Truth in Lending Act, TILA. Next, you'll need to gather all of your signed loan documents from your records, from your escrow company, or your lender. It is important to have a complete loan file. Get the loan documents reviewed by a qualified attorney or a reputable loan auditing company. At this point, your attorney should be able to advise you if you have a strong enough case to move forward with litigation. However, I caution you, litigation is both costly and risky. A 3rd option available to homeowners is plan on moving. Get a qualified short sale agent to help you get rid of your home, but only consider signing off on a short sale agreement if you get a complete release of liability in writing from the lender. 4th option, consult with an experienced bankruptcy attorney, as the bankruptcy laws may offer some very cost-effective ways to eliminate unsecured and undersecured mortgages and keep your home, or at the very least offer a last resort bailout strategy to eliminate all of your debts, including mortgage-related debts, and allow you to plan the timing at which you will surrender your home to your convenience. A 5th option available to homeowners, and one that I would encourage all homeowners to explore, is a combination of all of the options provided earlier. You may be able to get rid of your home with no liability, restore your credit, maybe even save some money in the process, and be able to purchase your neighbor's distressed property at below fair market value. Why? Because your neighbor failed to understand his or her options early on and did not develop a good plan moving forward. Therefore, they were at the mercy of their lender. I tell people it can't hurt to approach your lender and request a loan modification, but it is often a lengthy and torturous process, often resulting in little or no relief. It is unfortunate, but Senate Bill 94 now limits an attorney's ability to perform foreclosure prevention services for upfront fees. Do not fall victim to loan modification scams and put little faith in your lender or promises by our government. Remember, it was the greed of these lenders, fueled by Wall Street's thirst for mortgage-backed securities and the lack of government supervision, that created the problem in the first place.